Good morning. Before we call the case, a couple of comments to the lawyers. One, Mr. Becker, you don't really look like Emily, but the name of their any bit.
I was wondering about that.
Yeah, I believe we figured out who you are. Before we start call the case, I want to thank the lawyers for participating in this Zoom in the process of hearing oral arguments this way. It enables the court to continue the work, its work for the people of the state of Tennessee, which benefits the people of the state of Tennessee and your clients. And that we've been able to keep matters going and keep them current. So thank you all. It wouldn't work unless the lawyers and the parties agree to participate though. So thank you for doing that. If we have any technical problems, don't worry. We'll simply take a pause and correct them. So things are working very smoothly. So I don't anticipate any, but if we do, we'll just pause and work it out. Call the case, please.
Louise Helen Pack Dover versus Norris Lee Dover.
We're here from the appellant.
Your Honor, good morning. I'm Jerry Becker from the Knox County Bar on behalf of Dr. Dover. Your Honor, I request a 5-minute time for rebuttal.
That'll be fine.
Your Honor, the parties, we have filed extensive briefs, and in this case, both the original appellant brief and then reply brief. But to summarize our position, Your Honor, as the court knows, the parties were married on June 17, 2000, and they separated in October of 2010. And then in 2011, the parties entered into an agreed order where my client provided for Ms. Dover and the parties' 2 children the sum of $10,000 a month to be used for their support and for their education. And that $10,000 a month continued up until and including the trial dates, which were in 2017. So over that period of time, Ms. Dover received approximately $800,000 of support for herself and for the children. Your Honor, at the time of the trial in 2017, my client was 63 years of age. Ms. Dover was 54 years of age. My client had retired in 2010, and in fact, his license had lapsed in 2012. The court will note in both briefs filed in this case that my client was the primary breadwinner in this family and worked consistently throughout the time the parties while the parties lived together. Miss Dover worked sporadically, had a variety of jobs, primarily in the interior design business, but at no time did the court find, nor was there evidence ever presented, that she was restricted in her abilities to work. There were no physical limitations and were no mental health considerations that would have prevented her from working on a full-time basis. What the court, and she stopped working essentially in 2002 after the party's older child was born. The court will note that the two issues that we raised initially on the appeal had to do with Ms. Dover being awarded 3 years of spousal support at the rate of $5,000 a month. And secondly, the issue involving the court's failure to discern a premarital portion in my client's 401k account. With respect to the issue of support, I would point out that Ms. Dover had led a very extravagant lifestyle during the entire time of these parties' separation. Her monthly affidavit concluded $2,500 a month for recreation, entertainment, and travel ball for the party's son who played baseball, and $700 a month for clothing for herself, and then another $2,500 a month for food for her and her daughter and her son. Under all circumstances, this appeared to be, I think, a rather extravagant set of financial requests. And I think the importance of that is that Ms. Dover was living at the residence that my client owned prior to the marriage during the entire time of separation. And as far as I know, even up to today. He paid all of the taxes on the property. The only thing I think she had to pay for was utilities. There was a HELOC.
Mr. Becker, let me ask you about that marital residence, because one of the issues that is raised by the wife is the fact that your client was awarded the marital residence as separate property. And it looks to me in reading through it that the chancellor did not consider her contributions as a homemaker, which is statutorily required in making that decision.
Well, Your Honor, the chancellor heard the testimony of both parties relative to their contributions to assets during the marriage. He listened to the contributions by Ms. Dover to any interior design work being done at the residence. He ultimately cut in half, I think, $184,000 that was alleged to have been spent on redesigning the house, and awarded her one half of that. And I think that in awarding her one half of that money, I think he took into account her homemaker contributions to the marriage. Again, this was property that he owned prior to the marriage, and he maintained it. The taxes, anything that had to be done in that house, he maintained it. And as the court would see, at no time was her credit, was she needed to participate in any refinancing or assumption of debt on that house. As you know, there was a significant HELOC that was taken out on that house, and it's because it had to finance certain debts that Ms. Dover had, both in terms of legal fees and other obligations that my client assumed the payment of completely. So he assumed the debt 100% for that house. And I think that the assumption of that debt, the fact that she got half of the contributions to the remodeling of the house, serves as an indication that her homemaker qualities were in fact taken into account.
Let me ask you this as well. With respect to your client's work history, if I'm remembering the record correctly, I know he left his employment, and that was because of the domestic violence allegations against him. That was in 2010. Is that correct?
Yes, Your Honor. Oh, yes, correct.
Okay, so if my math is correct, his forced retirement age was not until 65. So I think he had about 12 more years available of work, but he has not worked since 2010. Is that correct?
That's correct, Your Honor. He essentially, I think, retired at the age of 57, and he did not take when he was asked to leave his practice. He looked at a couple of opportunities. One was up in Johnson City. Another one would have been in Roane County, but there were malpractice considerations. And long and the short of it, my client was hopeful of trying to reach some sort of reconciliation, particularly with respect to his contact with his children. That didn't happen. And he did not, and another job potential was down in South Carolina. But because of the geographic concerns of not being available to see his children, even when he was seeing them at parent place, he turned those opportunities down. So his license lapsed in 2012, and he did not seek any reinstatement of the license or work after 2010. And as the court noted, we're not.
Mr. Becker, let me ask you, your time's getting short. Why don't you talk about your issue on your client's 401k?
On the 401k, Your Honor, our position is this, that both parties recognize that there was a premarital component. Ms. Dover had said in her testimony that she recognized that to be $385,000. Our position is that the premarital amount came to $656,080.66. The problem was in providing the documentation for that. We were able to finally obtain some document from the retirement, I think Meridian, which showed that at the time of the marriage, the premarital value was $656,080.66. We asked the court to consider that in dividing up that 401k, and to take that out of the 401k, then divide the balance in half.
Well, when did you ask the court to consider that? When did you get the documents?
Well,
that wasn't a trial, was it?
we filed the motion to alter and amend. And
Yeah,
I
let
think
me ask you something on that, Mr. Becker. Sorry to interrupt, but the case had been pending how long between the time it was filed and the trial?
Your Honor, many years. I don't have a.
Many years, and you couldn't get those documents until after trial?
Well, Your Honor, there was testimony about these documents or about this amount during the trial. We filed the motion to alter amend when we were able to finally get the document. We were able to get it because we continued to look and to look and to look. We finally got the document. The appellee, counsel for the appellee objected to it on the doctrine of completeness. It was allegedly a 3-page document. The last two were boilerplate provisions. The first page contained the amount that was premarital. And more than anything, I think the testimony of Ms. Dover was that she took issue with the $600,000 valuation, but she said it was $385,000, and that my lawyer had papers to that effect. Long story short is that both parties recognized there was a premarital component.
And so you're saying that the wife testified that the premarital component was $385,000?
Yes, Your Honor.
And the trial court treated it as zero?
Yes, Your Honor. If you look at in our brief pages 39 and 40, and if you look at the transcript, volume number 6, lines 99 to 100, in that the question was, and so do you know how much was premarital? Her answer was, I think it was around $385,000. If I am not, question okay, and answer, Ms. Easterday has those records. So it appears to me that at the very least, Your Honor, this court should look at the range of $385,000 versus $656,000 in computing a premarital component. Nobody disagrees there was a premarital component. Nobody. The question is the amount.
Okay. Thank you, Mr. Becker. You have your time for rebuttal.
Thank you, Your Honor.
We'll hear from the appellee.
Good morning, Your Honors. Allison Easterday and Haley Chastain here for the appellee, Louise Dover. In regards to the 401k account, husband's brief is void of the facts. Husband suggests that he testifies that the value of the pension and the 401k was $656,000 as of the date of marriage. But Dr. Dover does not have independent memory of the exact account balances that are 17 years old, and that's just not what happened at trial. What happened was on March 17th, 2017, during husband's trial testimony, he attempted to introduce a one-page of a multi-page statement, a statement that was clearly incomplete. I objected and the trial court sustained my objection. Trial Exhibit 53 was marked for ID only, so the amount is not in evidence. 6 weeks later, the trial resumed.
Before you go to the 6 weeks later part, did your client testify that there was a premarital component to the 401k?
Yes, she was asked, and her quote was, I think it was around $385,000.
And the trial court, in dividing that, treated it as zero.
Yes, saying that there was no reliable evidence because, one, his testimony didn't come in, the statement didn't come in. There was a supposition
what about your client's statement?
Right, that's the only evidence is, and what's the best evidence here? The best evidence would be the statement that clearly Dr. Dover had the ability to get. He waited 7 years to get it. And this trial was pending. 6 weeks later, we came back to court. He had the opportunity to produce it and didn't. 3 months later, we had closing arguments. He had the opportunity to present the statement and he did not. 8 months after the proof was closed, lo and behold, the statement appears. I've mentioned in my brief the discovery issues we had during this entire case, having to file motions to compel, petitions for contempt, orders for contempt going down, having to subpoena the information ourselves. The court must look to the factors. One, this was not newly discovered evidence. It's been available to Dr. Dover since 2000 and during the 7 years of litigation. My client did not contribute to the delay of introducing this evidence, and allowing this evidence in, indicating that the value is $656,000 of premarital would be highly prejudicial to my client. Now, Dr. Dover is asking to rely on my client's supposition of, oh, I think it was $385,000. That's not as reliable as the best evidence of the statement that was available to Dr. Dover. The trial court correctly concluded that the only evidence presented at trial was a statement 3 years into the marriage, and was unable to determine the value as no evidence to establish such value was presented. In regards to the real property, there's a clear error of law and misapplication of the statute. Husband and the trial court confuses two legal principles, one being the appreciation of separate property being marital and the need to prove substantial contribution versus transmutation and commingling. This is a clear case of transmutation and commingling. There is no dispute as to commingling. The parties and the court found on all properties that marital money from the joint account was used to renovate and pay for all expenses. The court and husband repeatedly rely on the factor that wife's credit was not used. Well, guess what? Neither was Dr. Dover's. They used cash from the joint account to pay for all of the renovations, to pay for the insurances, to pay for the mortgage, to pay for the taxes. In regards to the marital residence, it was just that. It was marital. The wife and the children lived there for 17 years. The mortgage, the taxes, the insurance, and general upkeep of the home for 17 years was paid from marital funds from a joint account. Testimony from both parties and the trial court made specific findings that marital funds from the joint account were used to pay $170,000 in renovations during the marriage, in addition to all of the other expenses I mentioned. Husband's actions over the 17 years by using the home as a marital home for the family, by putting significant marital funds into this asset, have so commingled it that it's been transmuted from a separate asset to a marital asset. Husband was awarded this as his separate property, but the evidence clearly supports a finding that it was transmuted into a marital asset. And the same is true for the North Carolina property that we refer to as the cabin. Testimony from both parties, findings from the trial court, that $480,000 of marital funds were used to renovate this piece of property. It only appraised for $440,000. So we have more money, more marital money from the joint account put into this property than it's worth. In addition, marital funds over 17 years were used for the upkeep, taxes, and insurance, all from the joint account. This asset is so commingled that more marital money, as I said, has been put in it than it's worth. So how do we distinguish which dollar is separate versus which dollar is marital? You can't. It has been so commingled. It was also treated as the family home. Both parties testified that the home was renovated and expanded to fit their family, and they spent time there every couple of weeks as a vacation home. Husband was awarded this as his separate property, but the evidence clearly supports the finding of transmutation. My client was awarded $50,000 for her interest in this home. It makes absolutely no sense. I have no clue where that number came from, other than that's the amount that husband requested wife be awarded. It is a completely random number that the trial court adopted. In regards to 111 Church Street, all parties in the court agreed that yes, husband had a 1/2 interest in this property before the marriage and that it was worth $2,500. $65,000 from the joint account of marital funds was used to prevent the brothers' foreclosure on this property. Then another $151,000 from marital money from the joint account used to renovate the home. That's a total of $216,000 of marital funds put in this property. Plus marital funds used to upkeep, pay the taxes, and the insurance for over 17 years from a joint account. This home, like the cabin, appraised for less than the marital monies put in it. This home appraised for $145,000, Again, this property is so commingled that more marital money was placed in it than its value, yet husband was awarded it as his separate property. And guess what? My client was awarded $0 for it, despite the proof that $216,000 of marital money was put in it and it only appraised for $145,000. In regards to all three properties, the court repeatedly and erroneously states that the funds put in the properties were earned by husband. Well, last time I checked, every dollar earned during the marriage is a marital dollar, with no financial contribution to wife. The court went on to say that husband was the sole earner and wife's contribution as homemaker and otherwise limited in her contribution financially to the family and marriage. Last time I read the statute, the contribution as homemaker and primary caretaker of the children was equal to that of the wage earner. But again, that's not even the standard to look at here. That's if you're looking at an appreciation of a separate asset. Here, these assets have been commingled such that there is a transmutation. Financially, the total of these three properties are worth $1,185,000, all awarded to husband as his separate, when it's undisputed that $865,000 plus mortgage payments, plus taxes, plus insurance, all came from a joint account from marital funds, all over 17 years. Yet my client, for her interest in all three properties, was awarded $134,000, 11% of the total value of the properties. That is unequitable. As of July 2019, Dr. Dover removed $163,000 from the 401k account after trial for the use as his sole discretion. The court refused to take into consideration or add back to the value prior to the division of this account. Yet, in husband's own reply brief on page 36, he states for his rationale, thus, appellant's withdrawal of the funds from the 401k during the subject time period allowed him to maintain the properties, plural, that are marital assets, plural, which is appropriate under the facts and circumstances in this case. Dr. Dover continues to use marital funds to pay for these real properties, even after the divorce. And he and the trial court claimed that they are separate property. The proof does not add up to that. In regards to the alimony, the trial court's finding that Dr. Dover and my client have equal earning capacity is absurd, as well as the finding that my client will receive substantial assets for all the reasons I just indicated above, and her receiving only 11% of the property. My client has a high school. Yes.
Let me interrupt you. Certainly, the education levels between these two parties are different, but what, if anything, did your client do during the almost 7 years that this case was pending to attempt to rehabilitate herself in terms of job skills, job hunting, education, anything like that, while she was receiving the $10,000 a month?
Her background was in interior design, and she continued to try and to develop that. It's important to note, and the court ignores the evidence that was put into the proof, that when this divorce initially was filed, these kids were 6 and 8 years old and had suffered abuse, as well as my client, at the hand of Dr. Dover. My client and these kids were in extensive therapy, okay? Teresa Dunn testified as my client's therapist that it wasn't until the end of 2013 that she was fully functional and able to even begin looking for work, because she suffered from extreme and acute post-traumatic stress disorder at the hand of Dr. Dover, okay? He's had no co-parenting time ever except for under a supervised setting at parent place. So my client has had these kids for 365 days a year. Dr. Lawrence testified, who was treating psychologist and an expert for the oldest child, Lee, that at his age, even at the trial of 2017, he was exhibiting provocative behavior. and that he required and demanded extensive time and attention and supervision from my client, even at his age, due to the abuse that he suffered from Dr. Dover. So when you look at all the circumstances, they were not ideal to just go, pull up your bootstraps and go find work. She was the full-time and only caretaker for these kids.
All right, counsel, what about the argument that he retired?
He retired at age 57 voluntarily. Even under his testimony, it was customary to retire in that field at age 65. He had another 8 years and had been earning $970,000 a year.
Well, but as I recall, and it was a long time ago, but the Supreme Court reversed me on a retirement case where I argued where I took the position that you taken, and they said, nope, retirement was a legitimate thing. Person could pick when to retire.
I guess the question is, at that age.
And now, having prefaced that, is there a difference between that voluntary retirement and alimony and child support?
Certainly. And I think here, my recollection of the case law is you have to look to the reasonableness of it. And so I believe the question is, at age 57, under a support obligation with a minor child of age 6 and 8, is it reasonable to retire and live off the marital estate? I would argue that it was not reasonable. He had a huge earning potential that he simply abandoned. In regards to dissipation, Dr. Dover goes on and on about paying 6 years of support and alimony, but it was paid from the marital estate. He had no earned income. Essentially, my client paid for half of her support, half of the child support, as well as half of his support and his attorney's fees. Yet my client is expected to pay her attorney's fees out of the half of the estate, or what portion, it's not even half of the estate, but the portion of the estate that she received. In addition, husband, while retired and under a support order, changed his investment account from a speculative profile in 2012, from a growth in income, to a speculative profile. Our expert testified that he would have never advised a client to do so. You might as well put it all on red. He lost $1 million while this case was pending. He doubled the line of credit on the home. He spent the entire account, First Tennessee account, of $250,000. And he constructed the barn at the cabin of $125,000. All while this case was pending, all in violation of the statutory injunctions, further dissipating the marital estate. Thank you, Your Honors.
Use your time. We'll hear from the appellant rebuttal, please.
To the allegations raised by Ms. Easterly Alexander, I just would point out that the issues of abuse are underscored or undercut by the statements of Ms. Dover as to what her average day was like. If you look at page 15 of our brief, you'll find out that Ms. Dover would basically get up in the morning, take the children to school, and then go work out, and then come back, pick the children up, and basically wouldn't do anything, perhaps tidying up the house, things of that nature. The testimony of her psychologist was that there was absolutely no restriction on Ms. Dover working. There were no mental health issues that would have prohibited her from working. She chose not to do so because she was getting $10,000 a month from Dr. Dover. At no time, with respect to the properties in question, did the parties ever agree that the title for those properties would be put in both clients' name, in both parties' names. The cabin the cabin and the lookout residence were owned by Dr. Dover prior to the marriage. Any obligations that were forced on those properties, particularly the HELOC, Dr. Dover took full responsibility for payment. The court heard Ms. Dover testify about what she did in the course of her day, what she did with respect to these assets, and the court was not convinced, was not moved that Ms. Dover was entitled to get anything more that she got. And what she got, by the way, based upon all the court's rulings, was that she got assets way in excess of $500,000. she was awarded $84,000 for his share of the marital residence, $50,000 for his share of the cabinet property, one half of the sales proceeds from the Dover store property, one half of the sales proceeds from the 100th Street property, a 2008 Mercedes, a 2015 Chevrolet, one half of Dr. Dover's health savings account, one half of his bank account, and a portion of the 401k, which we believe would have been, under our calculations, at least $384,000. So she was getting assets well in excess of $500,000, probably closer to $600,000. He also had judgments against him for $45,000, which he was required to pay her. Also, he was to pay another $21,000 for portions of the children's uncovered medical expenses. So Ms. Dover was coming out of this situation again with assets and funds and liquidity in excess of $600,000. She had more than enough opportunity to put monies aside to prepare for a future. She chose not to do so, and now she's asking this court to give her another 3 years, which, by the way, my client paid from the time of the initial findings of fact, conclusions of law in 2017. Dr. Dover was ordered to pay her 3 years of support at $5,000 a month. Those 3 years are up. He paid that during the entire time period. She was supposed to vacate the Lookout residence 60 days after the school year in 2018. She's still in 2019. She was supposed to vacate. Excuse me. Ms. Stoltz just told me that the final order for divorce came down in 2019. She was to vacate the premises in this summer of 2020. As far as we know, she is still not vacated the premises.
Well,
So
that's not, Mr. Banker, that's not in the record, is it? The fact that whether she is or isn't still in the premises.
No, you're right, Your Honor. I apologize. It's not. Long story short is that Dr. Dover has met all of his financial obligations to Ms. Dover. She has chosen not to be responsible in the assets that she obtained, and now she is asking this court to award her greater assets that are not borne out by the record presented to the trial court, nor are they borne out by the arguments of counsel before this court. Thank you very much.
Thanks to counsel for both sides. We appreciate your briefs and your oral argument on this. If you would, please recess court until 11 a.m.
Thank you, Your
This
Honors.
court is in recess until 11 a.m.